for joining today's session. Today's session is entitled Changes to Medicaid and Cardinal Care. I'm 𝐲𝐢𝐬𝐀𝐛�𝐥𝐢𝐭, your moderator, a dLCV employee. Our presenter today is Emily Hardy. Emily Hardy is the Virginia Poverty Law Center's Deputy Director of the Center for Healthy Communities and Elder Law Attorney. She has experience litigating complex Medicaid appeals, and she also advocates for administrative and legislative improvements to the Medicaid program. She is a white woman with dark hair and wears glasses. Her preferred pronouns are she and her. Before we get started, there are a few housekeeping rules we'd like to address. Speakers, remember that we're using live captioning and interpreting services. When you first introduce yourself, please include a physical description of yourself and your preferred pronouns, such as, for me, it would be, I'm an African-American woman with curly brown hair and I wear glasses. I'm wearing a blue shirt. My preferred pronouns are she and her. This will help provide context for attendees who may be blind or vision impaired, and will also help our interpreters and captioners locate who is speaking on the screen. Please stay muted at all times unless you are the speaker, and please hold all questions till the end. We do have a chat box, and that's used for questions only, or if the speaker directs me to put something in it. At the end of the session, we will select some questions. If your question is chosen, you can take yourself off of mute and ask your question. Now, here's Emily Hardy.
Hi, thanks so much. As was just listed, this is the Virginia Medicaid program, and we're going to talk about sort of the system as a whole, as well as some of the recent changes. Again, thank you so much for the description, and I'm Emily Hardy, the elder law attorney with VPLC. If you want to go to the next slide. So Virginia Poverty Law Center, if you're not familiar with us, we're an advocacy agency who works on advocacy, education, and litigation, working on assisting people across the state of Virginia to get rid of the barriers that keep people in poverty. Next slide. So we're going to start with some of the basics of the Medicaid and FAMOUS programs. Next slide. Sorry, that one's very short. So what is Medicaid and FAMOUS and how is it run? So it's a federally run program. At the federal level, it's the Centers for Medicare and Medicaid Services, also known as CMS. They contract with the state of Virginia to run the program here, and that is run through the Virginia Department of Medical Assistance Services, and they further contract Virginia's Department of Social Services to do the application, processing, and case management. So there's a lot of different layers in the Medicaid program and agencies through which this program is run. There are also multiple different categories of Medicaid within both Medicaid itself and FAMOUS. And to make sure that it's as complicated as possible, each category has different financial and non-financial eligibility rules. So the program is very big and very complex because all of these different categories have different roles. This is in part because Medicaid has come to be through continuous updates over the years. So the program has had different additions in different years, which has added to the complexity. And so you would think if you're in a household with other people, you would all have the same eligibility, but unfortunately, that's not how it works here. So different household members may have different eligibility depending on what category and sort of what their other benefits they may receive or what other income they may receive. The last 3 years have been a difference for the Medicaid program because people were not renewed in the past 3 years. And it's only now since about March of this year, February of this year, that the annual renewal process has restarted. And so what that does is it means the state has to review every year to make sure that you remain eligible for the program. And if so, what category of eligibility you're currently in. So during the public health emergency and the pandemic, those renewals were not done. Next slide. So here are some of the big categories of coverage. We have coverage for families and children. So the categories of Famous Plus and Famous are children under age 19. And the difference between the two depends on income. So one is for a slightly smaller income bracket and one it goes a little bit higher. Pregnant women is Medicaid for pregnant people, Famous Moms, and Famous Prenatal. There's low-income families and children, foster care and adoption assistance, and children up to 21. And then former foster care youth, which ages up to 26 to get Medicaid. And for that, there's no income limit. So it's one of the few programs that does not have an income limit. Some of the other programs will have income, but not resource limits. And some programs have both income and resource limits. So again, complicated depending on the category. Medicaid expansion. Virginia expanded Medicaid in 2019, and that's for individuals between 19 and 64 years of age who do not receive Medicare or are otherwise not eligible in a different category. The age blind and disabled category, or ABD, is what you might consider traditional Medicaid. It's what was the type of Medicaid that we had initially was associated with SSI program. And so in many ways, there are a lot of cross similarities between that and what SSI requires. However, there are expansions even in the ABD group. It includes protected covered groups, which are people who at the time, primarily if somebody had SSI during certain time periods and was switched to SSDI, creating an income increase, they may still be eligible even if their income is a little bit too high because they meet one of these protected covered groups. In general, ABD is income under 80% of the federal poverty line, but there is a medically needy category, which allows people who have higher income levels to basically have high medical costs that lower their income to make them eligible. And so we'll get into sort of what the medical needy spend down is and how that's calculated later. There's also Medicaid Works and the 300% SSI category for certain programs. We also have limited benefit categories, which means although you're not covered for all of your medical expenses, you might get certain things covered. So we have Plan First, breast and cervical cancer treatment, the medical needy program or spend down program, and then Medicare Savings Program and emergency Medicaid. The Medicare Savings Program is a program that couples for people who have Medicare, and it allows certain things like your Part B premium or your co-pays to be paid for Medicare, but you wouldn't have full Medicaid under that program. Next slide. So most Medicaid programs have non-financial requirements as well as the financial ones. In general, you have to be legally present in the US and a citizen or have qualified immigration status, meaning that you came over on a specific visa or you're here on a green card. There are different rules for types of immigration status on when Medicaid can start for you. So it's very dependent on what specific immigration status you had when you came over and what category you fit into, whether you have to wait a period of time to start Medicaid or whether Medicaid may be available for you immediately. Sorry, if you can go back a slide. Thanks. Eligibility for children and pregnant individuals is broader than eligibility for non-pregnant adults in Virginia, and some exceptions for the immigration status include emergency services and Famous Prenatal, so for individuals who are pregnant. You're required to have Virginia residency to get Medicaid here in Virginia. So if you move to another state, you would need to end your Medicaid here and apply under that state's rules. However, if you're just leaving for a short period of time, but your residency remains in Virginia, that's a different situation and you can maintain Medicaid here. The Social Security number is required for most applicants. Obviously, if you're a non-citizen applicant who meets an immigration status or is applying for emergency services or famous prenatal, you may not have a Social Security card or Social Security number. And if there are instances where the local DSS will believe you need it, but it's just not always required. You're also required to assign rights to Medicaid, meaning if you were to get money through a settlement or something else, they may be eligible to a portion of it to help pay back the costs of your medical care related to that accident. You have to agree to apply for other benefits to which you're entitled. So if you are eligible for Medicare, you're supposed to apply to get Medicare, things like that. Or if you have insurance through your job, you have to get that insurance. Institutional status requirement depends on the type of coverage you're requiring, but if you're trying to get long-term services and supports, you have to meet that bar to say that you're institutionalized to get that care. And again, there's certain covered groups that get coverage based on their categories, and it's age, pregnancy, disability, SSI, foster care are some of the examples. Next slide. So we're going to go through what we would call the MAGI covered groups. And MAGI is the specific calculation of income. And so the ABD income calculation, and then these groups are done differently. So the way that they determine your eligibility for income is different in those two categories. So this primarily covers children, pregnant individuals, and then low-income adults, which is that 19 to 64 Medicaid expansion. Again, they have income limits, but these groups have no resource limits, which is a big difference between this and the original ABD categories. Next slide. So this slide is very full and busy, and it's just going through how do they calculate income for that MAGI group. So first off, what do they count when they say it's income? It's going to be wages, profit, your Social Security disability or retirement, rental income. So it's most sources of income that would be something you would put on taxes. They do not count child support, TANF payments, SSI, workers' compensation, VA benefits, so veterans benefits, gifts or inheritances, and Social Security of dependents who don't file taxes. So there are a significant number of sources of income that don't get added into this category. The determination of who is in your family group is important because there are increases in the amount of money and income you can have depending on how large your household is. So there's two main types of households: tax filing households, meaning that every year you file with IRS, or non-tax filing households, meaning that you don't file taxes every year. In general, children's households are going to include the parents they live with, and pregnant people will include unborn children in their household size. There can be instances where someone, such as a grandparent living with a family, they would be their own individual household, whereas their children may include the grandparent within their household. So it can be different within a household for individual members. So it is complicated. If you're confused, you can reach out to Enroll Virginia for assistance with figuring out if you're eligible and helping you do the application and make sure that everything's being assessed correctly. For non-tax filing households, it's going to include parents, step-parents of living in the house, children under age 19 if they're living in the home, and a spouse if they're living in the home. So it's really focused on who is living together in the house. Next slide. So we're going to go through some of the income brackets for the various programs. Again, for Medicaid for children, which is one of the categories, the main difference between this and FAMOUS CHIP is going to be the income limit. So Medicaid for children, FAMOUS Plus, is up to 148% of the federal poverty limit. And then we have the CHIP program, which is also going to provide insurance, and that goes from that 149 to 205% of the federal poverty limit. And in order to be eligible for CHIP, they have to be uninsured at the time of application. Early periodic screening, diagnosis, and treatment is an assessment that is available for all children under 21 who are on Medicaid. And what it does is require a second look to make sure that care is being provided to individuals. So if Medicaid denies coverage of something under EPSDT, if it's screened and found to be medically necessary, they are required to provide it, even if initially they said that it wouldn't be provided. Some of the ways we've seen this assist people who were previously denied some kind of coverage would be through some of the home care options, where the MCO may have said this person, the managed care organization may have said this person did not need this type of treatment. And then when we went back in and asked for this EPSDT screening, that screening said, actually, you do need to cover for this individual to this level of care, this many home hours, which were previously not covered. So it's a very good and important tool for people under 21. Next slide. So this next category is pregnancy-related coverage. There's 3 different groups. The first is, again, similar to FAMOUS Plus for children. It's up to 148% of the limit. There's no resource requirements, and it continues for 12 months. The expansion to 12-month coverage was recent in the last couple of years, which we think is a really good and important change because people can have complications that need to be addressed. The next category is CHIP again, and it goes from 149 to 205, just like for children. It also continues for 12 months, and similar to CHIP, you have to be uninsured at the time of application. The final category is also new within the last several years, and it's FAMOUS prenatal, regardless of immigration status. So for individuals who do not meet a specific immigration status, like we talked about in the earlier slides, they can still be eligible for Medicaid to assist with prenatal care, and it's up to 205% of the income limit. It does not continue for the full 12 months. It's only a 60-day coverage, and it must be added through a change process if the child also needs to be insured, and you have to be uninsured at time of application. We have seen people have difficulty with the CHIP for regardless of immigration status. So if that happens to you and you need assistance and it's not happening quickly, because some of these are supposed to be processed within 7 days, you can contact Cover Virginia for assistance or Enroll Virginia to try to help speed that application process along. Next slide. So Medicaid expansion, that happened here in Virginia in 2019. Most people, I think because of timing, everybody who was on Medicaid expansion since we opened it has never gone through a renewal process because of the public health emergency. So for individuals in this category, the unwinding process happening now is going to be the first renewal that you've gone through. Again, it's people between 19 and 64. You cannot be eligible for Medicare to be in this category. So if someone becomes eligible for Social Security disability, and then after the waiting period becomes eligible for Medicare through that, they would then no longer fit into the Medicaid expansion category and would have to get Medicaid through a different category if eligible. It has a higher income requirement than standard Medicaid. It goes up to 138% of the federal poverty limit. It has no resource requirement, meaning they don't look at how much you own. And if you have money in the bank, that's not something they consider. There's also no spend down or medically needy coverage, meaning if you're above the 138% of federal poverty line, it's a strict cutoff and they don't kind of go up higher and then let you spend down. You can be eligible for long-term care under this category of coverage. and there's no resource limit for it, unlike other categories. But the substantial home equity rule, we'll talk about later, and asset transfer rules do apply to this group. And if you were to receive long-term care as a Medicaid expansion recipient, when you turn 65, you would be reevaluated under the Medicaid ABD category and have to meet those criteria moving forward. There's also no patient pay for long-term services for Medicaid expansion. Next slide. So here's sort of the chart of the eligibility rules for income for these different groups based on household size. I'm not going to go through them individually because it is a lot of numbers, but it will be included in the slides. And if you look at the bottom of the sheet, there is a link to Virginia Healthcare Foundation Sign Up Now, which includes an expanded version of this chart that you can look at to determine if your monthly income might fit within these categories. Again, the way it's calculated can be complicated, so if you need assistance figuring out, you can call Enroll Virginia or Cover Virginia for assistance. Next slide. So we talked a little bit about some of the foster care programs. So individuals in foster care are covered under Medicaid up to the age of 26 if they're in foster care on their 18th birthday in any state. So it doesn't require that you were foster care here in Virginia. If you move here, you would still fit into this category up to your 26th birthday. There is no income requirement and no resource requirement. So again, it's supposed to make sure individuals who are in foster care continue to receive medical assistance until their 26th birthday. And this 26 age aligns with some of the ACA requirements that allow families to keep their children on until 26 in general. So it's a good change, and it's a good coverage option for people who need it. Next slide. So now we're going to get into eligibility for ABD, which, as we sort of discussed throughout, was one of the older programs for Medicaid and the more complicated one. Next slide. So similar to the household size, the first thing you have to figure out in Medicaid for ABD is the assistance unit. So there's complicated rules around who would be considered in your assistance unit. So for income eligibility, it's different than resources. If married individuals are living together, they are always going to be an ABD couple for resource determinations, meaning sort of regardless of if both are eligible for ABD or if one is working or not working, in any circumstance, they're included together for resources if they're living together in the same house. There is one large exception at the bottom. But for income eligibility, they're considered an assistance unit when both are trying to become eligible for ABD, they'd be an assistance unit, or if the non-ABD spouse, meaning someone who is not age blind or disabled, has income, then they're considered one assistance unit. However, if the non-ABD spouse has no income, they would be a unit of one. The person applying is a unit of one. And the reason for that is that if your income is included, then your expenses are included as well. So the spouse who's not applying for Medicaid, if they have income, then any of their medical expenses are deducted. But if they don't have income, their medical expenses are not deducted. So again, it's complicated. It's based on the SSI rules around spouse deeming. So additionally, if there are any children of the couple living in the house or either member sharing living quarters, they can all be in a household, meaning their income is included and their expenses are deducted. And then disabled children under 21 who live with a legally responsible parent, the parent's income and resources are deemed available to that child. So additionally, like we said before, if income is deemed available, then expenses can be deducted. The one large difference is where someone is institutionalized. And in that case, the individual is always considered a household unit of one. And when we say institutionalized, we're including people receiving care in home under the Home and Community-Based Services program. So if one spouse in the home is getting home care, they are a unit of one, regardless of the income of either party, they're always going to be a unit of one. And that would be the same with a child living in the house, that they would be a unit of one. So that is a big and good exception that allows people to only have their income and only their assets evaluated for home care as well as for nursing home care. Next slide. So again, the income is different and lower for ABD. It is in 2023, it's based on the federal poverty line, so it changes every year. In 2023, it's $972 per month for one person, and it's $1,315 for two. So it's not double, it's similar to SSI, it's an increase, but it's not double for two people. Generally, when evaluating your income, everyone gets a $20 exclusion, whether it's earned income or unearned. When we say unearned, we're talking about things like SSI or retirement or pensions, things that are stable income sources, but you're not currently working. Earned income includes that $20 exclusion, but additionally includes $65 exclusion plus half of all earned income being disregarded. There are also blind work expense deductions, student child income exclusions. Self-employment, it would be the amount of money that you earned. The ABD limit is based on the federal poverty line. It is, I believe, in Virginia, 80% of the federal poverty line that the income limit is based on, which is why it changes every year. Earned income, sorry, that was a question in the chat that I was responding to that asked what the ABD income limit is based on. So yes, it is based on the federal poverty line, which is why it changes every year. And then earned income tax is also is excluded, and then earned income used for pass is excluded. So most of these exclusions and exemptions are similar to SSI's exclusions and exemptions, and that's what they're based on and where they come from. Next page. So the exception where your income is above that limit that we were just talking about is a medically needy spend down. And the medically needy spend down is calculated for individuals who are trying to receive Medicaid as their primary insurance differently than individuals who are trying to use Medicaid for long-term care, meaning nursing home or home and community-based services. If you are in the community and you just want Medicaid as your insurance, but you're not looking for home care, it's going to be calculated on a 6-month period in Virginia. We're one of, I think, only 2 states that does a 6-month budget period. And so what happens is they look at your monthly income they've calculated. They subtract out all of your income exclusions, which comes up with your accountable income. They times that amount of money by 6 months to get your budget period income. And then they'll subtract the semi-annual medically needy income limit by locality, which is what is listed in this chart. And that also changes every year. And so once they've subtracted that out, they say over a 6-month period, your spend down liability is this money that's left over. So you have to have accumulated medical debts that reach this amount of money to get medical coverage in that 6-month period. If you are receiving long-term care, so nursing home or home care, your budget period is only 1 month. So it's calculated month to month rather than on the 6-month period. Next slide. ABD, unlike the MAGI categories, requires reviewing your assets to see whether or not they're a resource and has a resource limit for amount of money that you can keep per month or that you can have as something you just own versus income you receive. A resource is going to be personal or real property that you have an ownership interest in and a legal right to use for your own personal support and maintenance. So not all items that you own as an asset would be considered a resource. It may depend on your ability to access them, to spend them. So some things maybe are not a resource because you can't actually access them. Where someone receives a large sum of money, an inheritance, other large dispersals of cash, it's going to be income in the month of receipt and a resource in the next month. So even when you just get your Social Security, the month you receive it, it's income. And if any of it's left in the account for that next month, that's when it becomes a resource that you own. If someone is resource eligible for one day of a month, they're going to be eligible for that whole month. So if you have too many assets, but you spend them down before the end of the month, you could be eligible because you've lowered your assets to an allowable amount. So the resource rules are incredibly complicated and could go through an entire presentation because they're based on all of the different categories. So we're not going to probably dive into it in this presentation because we don't have enough time. But where certain resources are found to be resources, they could still meet some kind of exclusion. A lot of those exclusions relate to homes, and there's burial exclusion exceptions where you may have purchased burial items. There are other things like that that are specifically allowed to be excluded from your resources.
Excuse me, Emily, it's another question in the chat. Can you see it?
So where somebody is paying, so where somebody is an adult child over 21, they would not be in the assistance unit if they're living in the house, if they're not dependent on the parents, but income that they paid to their parents for rent and expenses and food would be treated as income to the parents. So that might come into effect that would raise the amount of income they have, but would not change their household size. Money in an able account, I believe, is an exception to being treated as an asset. So that's one of the specific ways that resources can be lowered if they're put into an able account, and the way that they are, put in and how they're managed affects whether or not it's an asset for ABD purposes. But yes, that is one of the ways that income can be lowered to make sure that you're eligible for Medicaid. Next slide. So the general rule for ABD is $2,000 in assets for one person and $3,000 for a couple. Again, for long-term care, you're always going to be a unit of one, meaning that the individual person is always going to have a $2,000 asset rule, not the $3,000 for couples. There is a community spousal impoverishment rule, which is done when someone first becomes eligible in order to evaluate total assets and move certain assets into the spouse's name for them to keep as their assets. There's also a maximum home equity rule of $688,000, meaning that if someone has a house worth more than that and they have more equity in that, they would not be eligible for long-term services and supports until the equity had been reduced below the limit. For MAGI, if you're trying to receive long-term care, no asset rules, but again, the transfer rules around it and home equity rules apply. So that's $688,000 home equity rule. For all categories of Medicare savings programs, there are more liberal rules on what can be excluded, and there are higher resource standards, meaning people can have more assets in the bank in order to get this more limited coverage, as well as having more income, because there's 3 different categories of income up to around 135%. So there's another chat. So for, yes, sorry, I saw the question. The adult child, for an adult child of 21 who is paying income, could they, and is living in the home, could they be considered a household of one? I believe if I'm reading your question correctly, yes. So they would be their own household, but the income that they paid to the parents would count towards the income the parents received in their household. So the rules on household relates to like children under 21 being included in their parents, but over 21, they may be a household of one. But the income that they paid, the rent they paid to their parents might still go towards their parents' income. Next slide. For long-term care, there is a 5-year look-back rule that's been in place since around 2006, 2008. And what it says is that the state can review transactions you have made related to your property and income for 5 years prior to your date of application to see if you have given away assets in order to become eligible for Medicaid. So it's a pretty broad category of what you may have done. And depending on your personal situation, sometimes they get really in-depth and can really dig into everything you've ever done with your money. So it can be a challenging process to go through. But essentially, if they determine you have given assets away for less than fair market value, they can penalize them. If you receive a penalty, but those assets you gave away are returned to you, that can erase that portion of the penalty for the value of the assets you get back. Sometimes transfers are allowed. Again, the rules are complicated, but transfers to specific people like a spouse or a disabled child may be allowed under the rules, whereas other transfers wouldn't be. A sudden onset of a disabling condition can be proof that the transfer you made prior to that onset was not made to qualify for benefits because you did not know you would need benefits when you made the transfer. Spousal resources are considered when assessing transfers, meaning that if something is in a spouse's name, they're still going to look at those assets as if they were available to the individual asking for benefits. Where a penalty is imposed and you would lose Medicaid because of the penalty, you could ask for an undue hardship to say that the penalty should be waived because imposing it puts your life at risk, your health, your safety, things like that. So that is a request you can make if there's no other way to resolve the penalty. So essentially you can argue that you gave it away for fair market value. You weren't aware at the time you would need Medicaid, therefore you weren't transferring it to become eligible, or if it's one of these other exceptions. And if none of those are applicable, an undue hardship is kind of the last thing that you can do to try to get that penalty erased. Next slide. So if you're trying to receive long-term care, whether in the community or nursing home, spousal impoverishment is a rule that allows assets and income to be transferred to the spouse of someone trying to receive care in order to avoid impoverishing that spouse. So I'll often refer to the other spouse as the community spouse, and then the spouse in the facility would be the spouse trying to receive Medicaid. Resources are a pre-eligibility determination, meaning when you apply, they do a resource assessment to figure out what items the community spouse can keep from your shared joint items, and whether or not after doing that assessment, the spouse in the facility has low enough assets to be eligible. You can get the evaluation when you initially apply, or you can ask them to evaluate prior to your point of application to figure out how they're going to assess your assets. The community spouse in Virginia can keep half of non-exempt resources with a minimum of $29,000. I believe it's $29,724 this year. It goes up every year, and a maximum of $148,620. So in practice, that means if somebody has $60,000, they can keep $29,724 up to basically half of 60 would be 30. So they can keep $30,000 if they have 60. If somebody has $300,000, they can keep $148,620. So it means that if you have less to start with, you can keep less, which is an unfortunate part of how it's set up here in Virginia. After evaluation, you have a limited time period to transfer any assets into the community spouse's name so that they are only owned by that person. And then moving forward, items owned by the community spouse are not going to be reviewed at renewal. And so actions they take with those items in future years are not going to impact the person receiving Medicaid for home care or nursing home. Next slide. The other part of spousal impoverishment is going to be income. And I put post eligibility determination because there's sort of two different ways we look at income for this program. The first is going to be to say, are you eligible or do you need a spend down to become eligible? And then post eligibility determinations are looking at if you're getting long-term care, what amount of your money do you have to pay towards your care? So what is your patient pay? So spousal impoverishment is calculated when you're figuring out patient pay, not when you're figuring out spend down. In 2023, the minimum amount of spousal maintenance is $2,465 per month, which means the money that that community spouse has, you can add money from the nursing home spouse to bring them up to that amount of money. So it's the cumulative amount for the community spouse, any income they receive plus income from the individual receiving long-term services and supports. There is an excess shelter cost where if your monthly expenses for your house go above a certain amount, you can increase the amount that the community spouse receives up to $3,715 per month. But other increases to spousal impoverishment would have to be done through an appeal. So if for some reason the community spouse has other needs, other expensive costs, they could appeal to the hearings division to ask the administrative law judge to increase it above that $3,715 amount. But an individual DSS caseworker cannot do that without an appeal. So it can go higher, but it has to be proven that it's needed and that there's some reason why there are more expenses for that individual. This money must actually be provided to the spouse. So if you ask for spousal impoverishment, but then the individual receiving home care keeps that money in their individual account, in their individual name, it will be treated as their money. So it has to actually go to the spouse. Important to note that when figuring out patient pay, there are other deductions available, such as medical, family member, and dependent child. So there are other things that can lower patient pay, not just spousal impoverishment. Next slide. So to apply for Medicaid, there are many different ways to get into the system. Common Help is supposed to be one application that you can use to apply for Medicaid, SNAP, all different sorts of benefits you might want. You can also call the Cover Virginia call center. The number is here. You can also apply in person at your local DSS. Again, for pregnancy coverage, they're supposed to do it within 7 days, and where it's not being done timely, you can call for assistance from Enroll Virginia to help you kind of figure out what might have happened to your application. It's supposed to be done within 90 days when a disability determination is necessary. So if you're trying to apply for age, blind, and disabled, but you have not had a disability determination through the Social Security Administration, and you need Medicaid to make that determination, they're supposed to do so within 90 days. And 45 days for all others. If approved, coverage is effective the first of the month that the application was submitted, and you can get retroactive coverage for most categories except 𝐶𝐚𝐵. And 𝐶𝐚𝐵 is a qualified Medicare beneficiary, and it's one subset of the Medicare Savings Program. And it's the one that has the most benefits. So 𝐶𝐚𝐵 includes paying your Part B as well as paying your co-pays for Part B. And so with 𝐶𝐚𝐵, it's the only one that doesn't backdate, which is unfortunate because we do have people who would really benefit from getting it backdated. Again, the annual renewal is required moving forwards and will happen every year. And it's only paused during the COVID-19 public health emergency, and it's been restarted. And people that are, I think we'll get to the unwinding requirements, but people are going to see paperwork for their annual renewal at different times throughout this coming year through, I believe, around March or April. Next slide. Okay, so the next section is eligibility appeals. I see a question. I believe the slides will be provided afterwards, and if not, I can certainly provide them. So for the disability determination, I believe it's that they have to go through the Medicaid DDS determination. They would have to try to make a determination within the 90 days if possible. And then I think it can take longer in certain circumstances. But I believe the 90 days does relate to if they have to make the determination internally, but I will double check and make sure there's not an extension for if Medicaid's making the determination instead of Social Security. Sarah, I will double check on that and get you the information on whether or not it applies to Medicaid works. Next slide. So for what can be appealed, it's sort of the broad category of things that you can say Medicaid, you made a wrong decision on. And so it's everything from the initial applications, if they deny your coverage, if they terminate you, if they suspend or reduce your benefits, if you think that they evaluated your income incorrectly or your resources incorrectly, if you think they did the spousal share determination, so spousal impoverishment or the spousal resource determination incorrectly, if they calculated your patient pay wrong or your allowances, if they calculated spend down wrong. So basically they made a decision, are there errors on it? You have the right to appeal and ask them to fix those errors. You also can appeal if they failed to take your application. And that's important because let's say you put your application in several months ago, you were trying to get 𝐲𝐚𝐰 and they didn't do anything with your application. If you apply now, you can't get that retroactive coverage. So appealing the original decision and their failure to take your application and process it would get you back to that original application date. So that's sometimes the reason why appealing is important, is because it gets you coverage further back than filing a new application. As someone doing Medicaid appeals, often I would appeal inaction, meaning I've asked for a change, I've submitted paperwork, and they've done nothing with it. If they should have evaluated and done something within that 45-day time period, my appeal would say, we're appealing your inaction on our request for a change. So when I was practicing, I used that as a catch-all where it wasn't quite clear that they had actually made a determination. And it instead seemed like what they were doing was sitting on the request. You can also appeal where there's been an improper notice. So they haven't provided you sufficient information. They haven't provided it in the language that you prefer, or they otherwise haven't met their requirements for due notice under the law. Next slide. Who can file an appeal? An individual or their parent, if they're a minor, so that seems obvious. If you have an authorized representative, they can file your appeal. And a power of attorney can also file an appeal on behalf of an applicant. A guardian can file an appeal, and then legal counsel can also file an appeal. One of the things that happens is sometimes facilities feel like they should be able to file an appeal, but they are not an authorized representative unless the recipient actually authorizes them to do the appeal. So where you're receiving home care, you should make sure that you are the one filing the appeal and not your MCO or care provider. Next slide. So where to file an appeal? You can file it online. You can file it at your local. You can get a copy of the paper at your local Department of Social Services, but you are not supposed to submit appeals to the local DSS. You're supposed to submit them to DMAS. If something goes to the local DSS, they are supposed to forward it on, but I would avoid submitting it to them to make sure that your appeal doesn't get lost. So you can appeal by email to DMAS directly. You can go through their management portal system. You can fax it to them. You can mail it to the DMAS hearings division. And you can also submit an appeal over the phone. Where possible, try to keep a copy of your appeal. And if you mail it, try to mail it in such a way that you get proof it was received, just so that if the paperwork goes missing, you can say, here's my evidence. This is the date I sent it. this is the date you received it, because dates are really important in appeal timelines. Next slide. So speaking of appeal timelines, an appeal must be filed within 35 days of the date on the notice or the postmark date. So if you get an envelope that shows that although the notice says one date, they didn't mail it for another 2 weeks, that's proof that you have this additional time to file your appeal. But you should always try to file it early just to make sure you get it in time. Appeals can be accepted late if the person has good cause. So some of the reasons: illness, if you were sick when this was sent to you, failure, they didn't provide you a notice in a timely manner, or they didn't provide you a notice at all, then you have good cause to file late. If there was a delay due to the postal service or they mailed it to the incorrect address, let's say you went to your local DSS rather than DMAS and filed it with that agency thinking that was the right place to file. If they receive it late, that should be good cause because you tried in good faith to file it correctly. Or if there's other unusual or unavoidable circumstances. So where you file late, you would have the obligation to show to DMAS why the reason for your filing late had good cause. When the appeal is started, your local DSS has to prepare and send to DMAS an appeal summary before the hearing and within 21 days of you requesting that appeal. And then the appeal decision must be made within 90 days of the appeal request. There's a couple of exceptions for that. So if you asked for a continuance, so you said, I need more time to get the records that they say they need, that could extend the 90-day request. And then additionally, during this period of unwinding, where there's a lot of different changes happening and a lot of appeals, the state has been given permission to have late decisions, meaning it can take more than 90 days from your request for a decision to come out. But there are some good things for recipients that come in line with allowing those late decisions, which we'll get to, I think, on the next slide. Next slide. Oh, maybe the one after. So the prior appeal process was talking about eligibility determinations, meaning they're deciding if your income and resources mean you can get services. Non-eligibility appeals are going to be, for instance, if you receive home care and they cut the number of hours that you have, or you're asking for a specific procedure and your managed care organization says no to it, you can appeal all of those, but you usually have to go through the managed care organization first. And that appeal timeline's a little longer. You get 60 days to file the appeal, and then they have to issue a decision within 120 days. Or sorry, I think they have the same 90 days to issue the decision. But once their decision is issued, you can then appeal to DMAS, which was the prior slide, to ask them to review what the MCO decided. And you have 120 days to do that. So it's a more complicated appeal process because it allows the MCO a first look at what their decision was to evaluate whether or not they think they got it right the first time before you get to the state fair hearing. Next slide. So this is the good thing that came from allowing the delay on hearings. Generally, prior to the public health emergency, you would have to appeal within 10 days of your notice to keep benefits. So if you're getting home care and they were stopping it, if you didn't appeal within 10 days, you did not get to continue home care during the appeal. And even if you got that appeal within the 10-day time period, if you lost, you had to repay the benefits that you had received during that time. So that is how it was before the public health emergency and how it will be again after unwinding is over. However, during unwinding, because they're getting that extension on hearing decisions, they have to automatically continue people's benefits during the appeal process, and there is no risk of repayment, which means even if you lose, you're not going to have to pay back the care that you've received during this time period. So that's a really wonderful thing that we're really happy is in place, and that if you have an appeal, you are not at risk of owing the state money if you lose. So if you appeal to keep your benefits during this time, it just has to be within the appeal window or good cause, and you will not have to pay them back. So just very good reason to allow the 90-day extension. We're really happy that this is in place for people while appeals are pending. Next slide. So this is a long list of appeal tips. Some of this is probably things you already know, but we find that local DSSs and DMAS sometimes don't follow through on these things. Appeals need to be held in an accessible manner, meaning that if you need an accommodation, another language, interpreters, they should provide those to you. If you need the appeal to be held in a specific location or virtually or in person, those are things you can ask for and they should help you with. This is one that I tell people all the time. A caseworker is supposed to assist you in obtaining needed documents if you cannot obtain them yourself. And where you are asking for DSS to assist you, I highly recommend putting that request in writing, using the word help, saying I'm asking you to help me obtain these documents. Because if you get to an appeal and a hearing officer sees that that caseworker did not help you with the request you made, that can be a reason to overturn the decision for them to help you and make a new decision. So they are required to assist you, even though I know a lot of local DSSs do not help people. But where you're making that request, put it in writing so you have proof that you made it. And you can now make it sort of at any point in the process because we have de novo hearings in Virginia, which allow you to bring in any evidence you have, even if you didn't submit it with your original application, and even if they hadn't already reviewed it. If needed, you can request to have an appeal expedited so it happens faster. So I'll try to finish really fast. You have the right to bring evidence and witnesses to the hearing. You can submit additional evidence up until the hearing happens and sometimes afterwards. And you should make sure your appeal summary reflects what you're appealing. And if the agency agrees to correct your case before hearing, make sure they do so in writing. Next slide. Next slide. So quickly, during the COVID emergency, states did not do the renewals. As we discussed throughout the presentation, those begin in February and they'll go through March. And when starting a renewal, the state has to confirm a person's eligibility through electronics if possible. And it's only if they can't do that that you'll be sent a renewal package. And what they're evaluating is what they always have. Are you currently eligible for services? To find out your annual review, you can call Cover Virginia. Next slide. So here's some quick tips. Make sure DSS has your current address and phone number. Check your mail and read it and return your renewal even if it's late because they're required to look at it so long as it's received within 90 days of a termination. If you need assistance, call Cover Virginia. Keep envelopes and other proof of receipt when notices are late. And then there's some rules around pandemic-related assistance and assets that allow those to be disregarded. So if you receive those, you can still be eligible. I think we have one more slide. And so next slide. So this is just really quick that Virginia went from 2 MCO programs to 1 in January. There should not be disruptions. And they are going to be going through the procurement process for MCOs this coming summer with new contracts, which may change what MCOs are available. But otherwise, the purpose is just to make it so that there's one program and everyone on the MCO is in the same program. And that's called Cardinal Care. Thank you so much. And this is the end of the presentation. So sorry I had to go through the last few quickly.
Thank you, Emily.
Just ignoring me. All right. Thank you, everybody,
I think you have one last question in the chat. Did you get it?
Yes, I see the question from Thompson. Are Medicaid workers or social workers to assist in gathering documents if requested in writing? Yes, so the DMAS policy manual, as well as federal law, requires that if you ask someone to assist you in obtaining things you cannot obtain on your own, they are required to attempt to assist you. If it's required information and they can't obtain it and you can't obtain it, at that point, you might not be able to become eligible, but otherwise they are required to try to help you. It's just something that often doesn't happen. And so let me just maybe answer in the chat as well. since the interpreter I know was gone.
I'm so sorry.
Okay, thank you, Emily, for that. And we will see everybody else in the next session.
Thanks.
Thank you so much.